you said you could preserve it with an objection on the record later.
Certainly, Your Honor. Yes, Your Honor, just for the record, last Thursday we had a hearing with Sergeant Pluger outside of the presence of the jury for an offer of proof to note an objection as to Sergeant Pluger's assessment of the use of force in this particular case. I made those Friday morning in chambers. During a chambers discussion, I made those same objections with reference to the motion in limine that had been filed prior to trial to prevent every single officer from coming in and giving.
Motion in limine, whatever he said, I always heard it called motion in limine, or limine, to limit information. And basically it says we want to have that not brought in. So that's what he's talking about. Also, right before this started, they had a off-camera discussion with the jury, and then when they came back, the judge said, okay, we've interviewed the jurors, and we have determined that it was not jury misconduct, and there will be no action. So something happened that one of the attorneys brought up something that a jury did, either talked to somebody, called somebody, looked at somebody, smiled, waved, did something. One of the attorneys brought up a possible jury misconduct. The judge did an investigation off camera, questioned the juror, and they determined it wasn't jury misconduct. There's going to be no penalties, and we're moving on with the trial. Now, that could be appealable later, because if they think the judge should have ruled it was misconduct, etc., it could be an issue. But that happened all off camera, so we don't know what happened.
Their 2 cents as to the reasonableness of the use of force. I made those same objections to Lieutenant Zimmerman's testimony, and I just wanted the record to be clear that that objection continued for that testimony as well.
Given their involvement with the case, Sergeant Pluger and Lieutenant.
So what he just did here is he said he made an objection in chambers, he made an objection earlier, he had a motion in limine, and the stuff was still brought up against his standing objection, and the court didn't rule on it. That's another possible appealable action. If a higher court says, hey, that was inappropriate, the judge should have stricken his testimony or warned a jury, and he didn't, that could help be a motion to overturn this ruling if it goes against him.
Lieutenant Zimmerman, I did allow the state to elicit, and based on their training and experience, I did allow them for the limited opinion that the amount of restraint was, I think Lieutenant Zimmerman said uncalled for, but that it was not appropriate. And so I denied the defense motion to suppress those opinions.
That's not a good thing. So he just brought it up to get it on a record, and now the judge says he agrees with the decision and he did think it was okay, and then he repeated the lieutenant's testimony. So it actually probably weighed more on the jury now than had he not objected. And that's why sometimes you don't want to object to things that you really can't help. But if he gets an appeal, then the objection will be worth it. But the judge saying he agreed, and then he repeated Zimmerman's testimony, I'm like, shit, you just made it worse. The jury's not only heard it when Zimmerman said it, and he shouldn't have heard it according to the objection, now you repeated it and you agree with it. Nah.
And I would just only note today, Your Honor, because we have at least 3 officers that are coming in to testify. I understand that Chief Arredondo will be testifying today, and I understand that the court is permitting that per policy and his policy decision makings for employment purposes. However, there are 2 other officers that are in the train. One is the commander, Katie Blackwell, who's in charge or oversees the training. I would note that, again, she has opinions, as well as Sergeant Kerr Yang, who is in charge of the crisis intervention program. Again, now,
this is a good point he's making. What the prosecution is doing is they want to bring in as many officers as they can to say and give an opinion that Chauvin was wrong. And then the jury during deliberation says, every officer says he was wrong, he must have been wrong. And it's kind of stacking the deck. You know, it's like bringing in the chief who just saw the video, or bringing me in because I saw the video. And I was like, well, I don't think he is wrong, and this is why. I mean, you just can't bring everybody in and stack the deck if it's not relevant. So he's trying to make sure that every officer doesn't get to give an opinion, because the only people that get to give opinions are experts. And then they can give an opinion based on their training experience, expertise, time doing the job, etc. So if you're not qualified as an expert, then you don't get to give an opinion. You only get to give facts, or what you saw, or what you heard, or what you smelled.
I'm concerned that what's going to happen is we're going to, and then we have use of force experts that are coming in. So I'm concerned that the state is pigeonholing expert testimony in through these officers, where
I
I
agree,
think that
they
these
are.
officers should be just allowed to testify. These are our training materials. These are our training policies. These are what we do. So.
And I am allowing the chief's testimony that the use of force was contrary to policy. It's Lieutenant Blackwell. That opinion, Inspector Blackwell. I'm allowing that opinion. But why Yang, are we crisis intervention? Are we trying to get in Mr. Floyd's state of mind through the back door here?
No, Your Honor. The proffered testimony of Sergeant Kerr Yang will just be regarding Minneapolis Police Department's crisis intervention training that they provide to officers. It's a 40-hour scenario-based training course in which paid actors come in and they go through various scenarios such that officers would be able to recognize people who are emotionally and behaviorally disturbed, and to be able to understand that some people are unable to comply with commands rather than being unwilling to comply with commands, and all goes to the reasonableness of the police officer and the actions that they take.
So Sergeant Yang is not offering any opinions per se?
He is not. He's only going to be describing the training.
And you have evidence that Mr. Chauvin took that training?
Yes, Your Honor.
Mr. Nelson?
Your Honor, that was my understanding of Sergeant Yang's testimony. It was limited to the crisis intervention program and training that officers go through. It is within the policy, that part of the de-escalation policy and things of that. And so what it would also include would be what officers are specifically trained to do to identify the difference between someone who is willfully resisting or intentionally resisting arrest versus someone who's having an emotional problem.
So I got a problem with them making this distinction between willing and unwilling. If a guy's trying to take my gun and he's unwilling because he's mentally unstable, does that change the fact that he's trying to take my gun? I mean, who cares if he's willing or unwilling? If he's doing something that requires action, then you take the action. What they're trying to do is lead people to believe that poor George Floyd didn't want to resist, didn't want to fight. It was out of his control because of the drugs. Well, then why can't drunk drivers say, I didn't want to drive drunk? It was the alcohol. It's not that I wanted to drive drunk. I couldn't stop myself. That's the slippery slope we get with this argument, in my opinion.
So just so I'm clear, there's not going to be any video shown and Sergeant Yang opining on whether this person was emotionally distressed?
That's correct, Your Honor.
All right, if it's simply a summary of the training that's provided and that Mr. Chauvin, his personnel record shows that he took that training, that's fine. Anything beyond that, including videos or opinions, I'm not going to allow.
And so, Judge, I think this touches on something that was technically reserved during motions in limine, was the issue of which training materials would be admitted, because Ms. Blackwell, Inspector Blackwell, both parties intend to introduce training records that the Minneapolis Police Department has prepared. Both sides have intended to introduce those. There has not been a kind of a determination, I think, as to does the state or the defense need to specifically prove that Officer Chauvin experienced that direct training, or is this just the general policies and training materials of the Minneapolis Police Department? That's what we had tried to work out, and it's not that we haven't. I just think the conversation got on the back burner.
Well, I'll just give you my thoughts and see if this answers any questions you have about it. My analysis of this is, we have said Mr. Floyd's state of mind is not relevant. It's the defendant's state of mind, his knowledge and his intent. And
Oh, very
part of
good.
his knowledge is based on training he's received. So a summary of the crisis intervention training he has received is appropriate. We're not getting into, I suppressed the psychiatrist's testimony about what was Mr. Floyd's, was that truly anxiety or whatever. I'm not going to let a trainer say, look at the video and give those kind of answers. But evidence regarding what Mr. Chauvin knew, what he had been trained on, which goes to intent and knowledge on the May 25th, 2020, are all relevant and would be allowed. So I guess what am I missing here, Mr. Nelson, that still needs to be clarified?
Well, I think we get into some problems is in terms of how a connection between had Mr. Chauvin actually gone through this specific PowerPoint presentation, right? So the way that and this goes to how the disclosures were initially given to me, and then how they were
But
subsequently.
why don't you switch places here?
He wants him standing up if he's talking to him.
Thank you, Your Honor. So it gets into certain issues. So Officer Chauvin, a 19-year veteran with the Minneapolis Police Department, has completed 844 some odd hours of training. As the court is aware from our continuing education, I go on the CLE and I report I attended this all-day long seminar, but within that all-day long seminar, there's 5 to 6, 7 different presentations. I think that's ultimately what we see here is we look at Mr. Chauvin's what are called workforce director training records, and it says he attended the 2020.
What he's talking about is we have like training stations sometimes. If you go, sometimes they'll have a 12-hour seminar or a 3-day seminar. So they send a cop to it, and in this seminar for 3 days, you're going to get 3 8-hour days, 24 hours of accredited training. But at that seminar, there may be a 2-hour block on auto theft. And, like I would have been teaching that 2-hour block on auto theft. If you come to mine, I talk about auto theft for 2 hours, you get 2 hours of training credit. There may have been a child abduction 2-hour class. There may have been a handling victims of domestic violence 2-hour class. And cops, when they go to these things, you get to pick what classes you want to go to. You can go to your weaknesses or your strengths or areas that you might be moving into. So if I haven't done a lot of domestics, I may go to the domestic class. If I haven't got a lot of auto theft, I may go to the auto theft. If I haven't done a lot of burglaries, I may go to the burglary block. And they run these 2-hour blocks all day, and there's more. You can't attend them all. You get to pick the ones that you want to attend to. So when he gets 24 hours training at this seminar, nobody can say what block he went to. It just comes back. He completed 24 hours training at the seminar on this day. And these were the ones that were available. So I don't know why they're not doing it computer, but that's just to put it for people that don't go to this training or don't understand what he's saying. He's not explaining it really well for the person that's never been to this training to understand it.
Use of force, phase 1 defensive tactics presentation. Now, what does that consist of? Has been virtually impossible to reconstruct. And it goes to primarily how it was originally disclosed to the defense, how it was disclosed from the police department to the BCA, from the BCA to the defense, and then that formed the basis of my earlier motion and earlier proceedings to get a copy of that BCA drive. So when I originally received these training.
So it sounds like the prosecution tried to hide shit from him, and he was only getting bits and pieces. And when he questioned and wanted details, and did they have details, or why didn't they have details, they either stonewalled him or said, we don't have it. Then he wanted a disc exactly of what they got, because they probably took things off the disc and only gave them things, because the prosecution gets to determine what's discoverable. I think that's bullshit. As a prosecutor, I get to say, I don't think this is discoverable. And if the defense never finds out I had it, then I'm good to go. But if he does find out I had it and he makes a motion to the court can look at it and go, you know what? I think it is discoverable. Then he gets it. So it puts the burden on the defense to find out what the prosecutor is freaking hiding. It's bullshit and it's a scam. Government already has all the decks and all the cards in the deck in their favor because they get the investigation. They have subpoena power. They can write warrants. They have the full investigative force of the DA investigator, of the police force, of other investigator statement. They've got all the decks stacked in their favor. And yet they still get to decide what the defense gets and what they don't. And if it turns out that they should have gave something they didn't, nothing happens. Nothing. It's a complete scam. And that's what I think he's arguing about.
Materials, for example. These training materials are 20 to 30,000 pages in PDF format. And you can look at some PDF of a PowerPoint presentation and it says use of force, academy, whatever the topic is. No frame of reference as to when this was.
This is a type of flooding that prosecutors use. He's talking about he's got one PDF on his training with 30,000 pages in one PDF document. 30,000 pages. So what the term flooding is, and I don't know what the legal term, usually it's just kind of like, let's give him so much shit that he won't be able to go through it, and maybe he won't find the stuff that we don't want him to find. So we just give him a whole bunch of bullshit. Like I request a document and they give me 5 boxes of documents. And the document I requested is somewhere in the middle of all those documents. And it makes me waste my time and effort to go through all those to find, and maybe I'll miss it. So that's kind of what he's talking about here.
Was given, who, there's no title, there's no dates, there's no information, who taught this course, who attended this course. And some of that information contains very important statements.
And it's important on who taught it, because I taught things that other defensive tactics instructors didn't teach because they didn't want to accept the liability. A lot of instructors did not teach the carotid restraint. I taught it because I thought it was effective and I thought guys know how to use it or should know how to use it. But there was other weaponless defense instructors that did not want to teach it, even though they could teach it. They're like, I don't want to accept responsibility in case somebody does it wrong, which tells me they weren't confident enough to do it right and to be able to explain it right and to know that, you know what, I taught it right. If they do it wrong, I ain't held liable. If they did it the way I taught it, and I know the way I taught it because I taught it the same way. So that's why each trainer will train differently. Some trainers will, be very conservative and teach only what's in a lesson plan straight out, just read it, and that's it. They cover the boxes, they get paid, and they get a check mark to the officer. Other trainers will train like if I was getting training, that's what I would want, and they go the extra mile and train better. And I would like to think I was one of those. Some people may say I wasn't, but whatever.
On the part of the Minneapolis Police Department. When I receive the BCA drive much later, and I look at them in their native formats, the reason I wasn't seeing the titles of these presentations or the dates of these presentations is because that's how they were saved on the drive. So it would say 2018 Phase 1 Defensive Tactics, right? So you know that this is now the training material from 2018 from the Defensive Tactics course, or it will say 2018 Crisis Intervention Training, whatever, 2018 Human Factors of Force Training. So the dates and titles of these courses were given on that drive. Now again, you can look and you can see in his workforce director training or his workforce director program that he got credits for this 8-hour day. But again, which presentations were given on that particular day, you can't, there's literally no way to put this together. And I don't think that the state would disagree with that.
Well, let's see if they do. Mr. Slisher, can you tie a specific training module to the date that Mr. Chauvin actually attended?
Your Honor, what we can do is first show the workforce director training, which memorializes what particular trainings, in-service trainings, the defendant has attended, and the titles of those different trainings.
Okay.
Then what we can do.
So the term memorialize is used a lot in training, and if it's not written, it didn't happen. If it's not documented, it didn't happen. Trainers have to keep good documentation. When I was working, every time I taught a class, I did a memo afterwards on who was there, what I taught, if I had any assistant instructors, if there was any problems, or how I was going to modify. And I kept all those records. So if I was ever testified on how many classes did you teach, where did you teach, blah, 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 I would have my documents. I don't care if the agency usually does something, you know, like, did so-and-so show up? Yeah, they showed up. Okay, they get credit for the training done. That's all we need. As long as they get their post peace officer standard training required amount of hours, that's all we're concerned about. So, you know, when it memorializes, is basically it's written in stone. We know it happened because it's written and documented, and we can prove it.
Is have the trainer specifically talk about the materials and curriculum that they've developed for those blocks of training. And
For those dates.
on those dates for that. So, for example, if it's going to be the fall in service, there was a PowerPoint presentation that was developed from the curriculum from that fall in service, and they can say that that PowerPoint training was in fact presented. And these materials, they get recycled from year to year. There's nothing markedly different, in my view, from one to the other. They cover the same generalized concepts. And so, from a foundational standpoint, I think it's pretty clear that the training, the content, was imparted on, in this particular class, and that the defendant attended that class.
Well, it seems that a necessary foundation, I think you'd agree, would be this is the training provided on this date that the defendant's records show he attended. Even if it's embedded with 8 hours of other training, I think that would make it relevant. If you have training, but you cannot connect it to a training that Mr. Chauvin was at, it's hard to say then that you've laid the foundation for it. But it sounds like you've got the foundation. Am I correct?
Yeah, I think it's pretty clear, Your Honor.
As far as the other issues Mr. Nelson's identified, that seems to be more weight. It goes to weight, and you can cross-examine on it and say this was a 3-slide PowerPoint in the midst of 8 hours of training on other topics, and that's pure, absolutely fine because it goes to the weight, the evidence, as opposed to its admissibility. All right, Mr. Nelson, one last comment.
Yeah, I guess, Your Honor, I'm not objecting to the admissibility of this training. The question becomes, I think, and I don't think that it's as easy as as it's presented. It's because even some of the things that they've said that they intended to introduce, which are that are clearly from the academy, from the police academy, they're not from in-service records, but it contains the information that may have been a part of some other training. That's where we. So, case in point, there's a PowerPoint presentation from the Minneapolis Police Academy about nerve manipulation and basically joint manipulation, nerve endings, and how to gain compliance through pressing or depressing someone's nerves. It's
that I just told you.
Should I already have
Did they say to you, went through different courses designed to train us up on use of force?